Much. Good morning, everybody. Again, Martin Fink, Royal Netherlands Navy captain. And our next first lecture of the day, we'll have three lectures. First lecture of the day will be about the principles, the laws of armed conflict, and then in the context of the laws of naval warfare, which is, as we shall see in the next few minutes, a little bit different than in the context of land warfare. Everybody knows that we're basically also following the Newport Manual. So if you are following it also through reading the books, we're at the moment we're at chapter 5. So the lecture that we're having is basically a description of chapter 5. This will be our outline. First, I will start with a few general remarks. Three to be very specific, so 3 general remarks, and then we'll briefly touch upon the principles and basic rules, and we're going to touch upon 4. So military necessity, we're going to touch upon humanity, and we're going to say something about distinction, and also a few words on proportionality within the context of the laws of armed conflict. So remember, not within the context of maritime law enforcement, which is a huge difference, and perhaps we can also talk about that a little bit more. So let's start off with the 3 general remarks. If I can get this working. All right. So there we go. When we're talking about general principles within the context of the laws of armed conflict. There's of course different reasons why we have this and what their different roles are. First of all, of course, that they provide the foundational role, the foundational fundament of the particular regime. In this case, the laws of armed conflict. So it's the foundation on which the law basically is built, as generally in all kinds of other laws and laws regimes. So principles basically give you the foundation of the regime. Secondly, also principles can play a role to interpret the rules that exist. There might be rules that are perhaps a little bit vague. There might be rules that are perhaps are subjective, or there might be rules that are not clear at first reading. Principles will give you some sort of guideline to find out what the actual rule would be, and how we should interpret it, the different kinds of rules within the LOAC regime. So interpretation is one role of it. The other, of course, is also the clarification role. Now, there's a lot of rules in the laws of armed conflict, but we have not made rules. We have not made rules of everything. So there are also lacking areas, and if there are lacking areas, then also the principles will give you a guideline on how to proceed with the questions, or with the questions of legality. For instance, there may be new methods, or for instance, there may be new weapons which do not have any rules yet. And how do we deal with that? How do we deal with the lawfulness of new weapons? If there is no real rule, then we have to go back to the principles and see whether these weapons, for instance, can indeed be lawfully used. So there's another role for principles and why they are important. Of course, principles also build a sort of coherency within the whole regime itself. So it should be that if we follow the principles as a whole, then the whole legal regime should be a body of law that has certain coherence. But having said that, there are of course also principles that are pulling pulling in different directions. For instance, military necessity and humanity are pulling basically in different directions. But again, principles as a whole, they should underline a sort of coherency within the whole legal regime. And lastly, the role of principles. I think is very important. Is that, as I said, the laws of armed conflict have many rules. We're now only talking about the laws of naval warfare and the rules of the laws of naval warfare, and perhaps only Wolf is the only one that knows all the rules of the laws of naval warfare, and the rest, well, we're trying to keep up with him. Sometimes he makes up rules, and we don't know whether he makes up rules. We just don't know. But the laws of armed conflict, there are many rules. Laws of naval warfare. We have occupational law. We have the laws of neutrality. We have the laws of targeting, etc. Many rules. And let's say the challenge that we're having as military is that we have to educate our soldiers, and we're not going to educate our soldiers and sailors by trying to let them know all the rules of the laws of armed conflict. So we need to have principles. We need to have basic rules for our soldiers, for our sailors, to let them understand how they can use the law within actual practical operations and actual practical decision making, because they will not be lawyers and we're not going to train them as lawyers, but they need some sort of a legal thought in their minds to be able to try to stay within the law and try to keep their actions legal. So that's why we finally end up with things like small soldiers cards that basically says, don't kill civilians, minimize collateral damage. If you capture someone, make sure that you treat a person humanely. Those very simple directions, but they are directions that give soldiers and sailors some sort of guidelines to ensure that they will ultimately and hopefully stay at least for a certain period within the law. So that is the reason why we underline principles a lot, especially for educational reasons, and I hope that will help a little bit in trying to do legal operations. Second general remark that I would like to make is, there is in fact no generally agreed list of principles within the law of armed conflict. So states and international courts and scholars, they sort of have endless discussion on what the principles of the laws of armed conflict should be. The International Court of Justice, for instance, made in one of their cases expressed their view that, for instance, distinction and unnecessary sufferings are the cardinal principles of the laws of armed conflict, and then the others will follow. Other states may disagree in that point. There is also discussion, for instance, on let's say the order or the categorization, which principles are more fundamental than other principles. There might even be discussion on whether some principles would follow out of other principles. Is the principle of unnecessary suffering the fundamental principle, or is in fact humanity the fundamental principle, and would the principle of unnecessary suffering, for instance, follow out of another principle? Proportionality, is that a principle by itself, or is this a principle which basically combines the principle of humanity, of distinction and humanity? So you will have different orders and different discussions on what the actual principles really are. Now let me try to find the clicker. All right. This is just just to illustrate that a little bit. Here's one scholar that tried to make some sort of a taxonomy of different principles, and you can see here on the left side here, he put military necessity, humanity, and issues like honor and chivalry, which are very, let's say, conceptual, overarching, maybe philosophical, hard to place law on issues like honor and chivalry, hard to translate it into issues of law. Then the principles that could be principles of law, for instance, distinction, precautions, humane treatment, superfluous injury, and unnecessary suffering. Those could be principles or general principles. And then there is also principles that might not be a principle, but actually might be a basic rule. Why? Because they are applied in very concrete circumstances. So one of this could be proportionality, and also the rule of distinction as opposed to the principle of distinction. So there's different forms of taxonomy, and this is just one scholar to illustrate that there is some sort of discussion with regard to the different principles that we have within the laws of armed conflict. Now, if we look at state practice, and we've discussed already the military manuals, if you also then go to the Newport Manual, chapter 5, you will see that the Newport Manual also has collated from the different state manuals the different views of different states. Um, and these are listed here on the screen, and you can find them on page 85 and 86 of your book. So you can see there are indeed some differences. And also, for instance, here, is this a laser pointer? No? Then I'll do it with my laser finger. So see, for instance, here Canada has divided it into primary concepts and operational principles. You know, I was talking about the different levels or different categorization. Now, Canada has, for instance, made it into two different levels: primary concept and operational principles. Germany only has two principles: military necessity and humanity, and which I guess it implies that all other principles will then follow out of these more cardinal principles of military necessity and humanity. The Netherlands here has a lot of principles where we go there: military necessity, humanity, distinction, proportionality, and also subsidiarity, which I think is a mistake. Simple as that. And hopefully in the new one that we are going to make, we'll have to change that. Because can anybody explain to me a little bit what subsidiarity would mean? In this case from a law enforcement perspective. So if you use force, subsidiarity would basically force you to think about whether the force is used should be the most minimum force that you can actually use. Now, this is a strange concept within the law of armed conflict, because we are doing status-based operations, status-based targeting. We'll discuss this a little bit later. So that's why, in my perspective, subsidiarity is not a real principle within the laws of armed conflict. Anyway, so you can see differences, but you can also see that there are principles that are similar to in every nation. Now, the San Remo Manual has noted 7 basic rules. They have not noted 7 principles, but they have noted 7 basic rules. And if you go to those rules, and those will be rules 38 to I think 44 or 45, you'll see that there are actually the translation of the targeting rules that are within the additional protocol 1. That is also because of Article 49.3 that we have discussed yesterday. So the San Remo Manual stays on the level of rules, basic rules. The Newport Manual has taken a different approach. So the Newport Manual has taken an approach that they will have 3 principles and they will have 3 basic rules. So the principles would be military necessity, humanity, and distinction, and the basic rules would be proportionality, superfluous injury, and chivalry. Which leads me to the third general remark. So the laws of naval warfare are part of the laws of armed conflict, which basically, as a point of departure, means that the principles of the laws of armed conflict also apply when we apply the laws of naval warfare. But having said that, and we've discussed this also yesterday and also during the conference, the laws of naval warfare are also influenced by other aspects of law, for instance, neutrality law or prize law, or indeed the international law of the sea. So if we then start to apply the different principles of the laws of armed conflict, you will see that there is in fact different forms and different ways to do it, which might be different than in the land context. Now, these factors or these practices, I'm naming here on this slide a few of these factors and practices and law to let you a little bit understand how the application of the general principles LOAC are different or are made different when we apply it. For instance, naval warfare has the platform-centric view as opposed to a person-centric view, which means that it will affect the way we do distinction, and it will affect, of course, then also the way we do our proportionality. The other thing is that, of course, the natural environment in which we operate is different. Usually it's empty at sea, and that is different than the current day land operations in which we do urban warfare, in which the issue of proportionality becomes a big issue. But if we then change warfare into outer sea, then again the sea is quite empty usually, which means that the principle of proportionality is not so big of an issue within the context of maritime warfare. The natural environment, of course, is also cruel. If you fall in the water, well, there's not a lot of time that you have left living. So humanity is, in that context, again, an important principle that we need to take into account. And of course, we have the Second Geneva Convention that has all kinds of rules translating the principle of humanity into rules, into international humanitarian law rules that apply at sea. So the natural environment is also important as a factor that makes the application of the principle of the laws of conflict different than in, for instance, land warfare. Then we have a historical practice also. So there is this historical practice that during international armed conflict, states tend to collide military vessels together with civilian vessels because of reasons of capability, etc., etc. So there is as a point of departure, there is sort of a general acceptation that during international armed conflict, naval trade or naval operations and maritime vessels will be very, very close together. And that is also the reason why we have different phenomena which you cannot find in land operations. Phenomena like which was already discussed yesterday, like the auxiliary vessel, which is not a warship, but is targetable. We spoke during the conference for the persons who were there. We spoke about convoy and the protection of civilian vessels within the context of convoy. Those concepts do not, up to a certain level, do not exist within the context of land warfare. So these historical practices would then also influence the way we apply principles of laws of armed conflict in the maritime dimension. And then the other point here, very important. Well, basically the two classic tasks of naval warfare, or tasks in the maritime domain for maritime forces, is defeating the enemy and economic warfare. So if economic warfare is still a task, then it should have rules. Which rules do we have for economic warfare? Of course, we have price law. But price law, keep that in mind, price law is actually directed against civilian vessels, because we are doing activities against civilian vessels, against civilian trade, to ensure that the opponent cannot sustain its warfighting activities. So also here, this will affect, for instance, the application of the principle of distinction. Now, all these factors and practical historical practices, they've influenced the law. We have rules on the use of false flags, which are different than inland. Things that we discussed yesterday, the treatment of crews on enemy merchant vessels is a result of the differences between land and sea, and also the liability of attack, for instance, on blockade breakers or vessels that refuse to stop, are all differences that flow out of this of the factors and the practices that we have within the context of maritime warfare. So yes, principles apply. However, if you apply them, they will be applied somewhat differently in this context. Let us then briefly touch upon the principles themselves. First, we'll touch upon the principle of military necessity. Military necessity, the definition here taken from the Newport Manual is here on the slide. Military necessity is the right to use all lawful means and methods of warfare to achieve lawful military effects, designed and intended to bring about the submission of adversaries' military and other fighting forces to the earliest opportunity with the least expenditure of one's forces. That's a very long sentence, but in any way, the essence of it is all lawful means and methods of warfare can be used for the submission of your enemy. Now, if we take that apart a little bit, and this is a very overarching principle, as I said, a sort of a conceptual principle. If we take that apart a little, then we just need to understand that necessity here basically has two forms. One is that there is a acceptation of a necessity that we can actually use force. So that is the context in which we apply force. Then the second context of necessity is that if we indeed apply that force, it needs to be necessary. So necessary force is allowed. Unnecessary force, there's the bar. Unnecessary force is not allowed. Now this is a principle that should not be used to circumvent the law. So you cannot say, well, there is a rule of the laws of naval warfare, but there is also military necessity, which means, you know, if it's military necessary, then I'm going to step away from the law and I'm going to do something else. No, the principle of military necessity is already factored into the law. This is an example of, albeit it's an example of land operations, but this is the one I could find quickly enough to illustrate that it's already factored into the rules of the laws of armed conflict. Or Article 23G of the Hague Regulations basically says, well, it's forbidden to destroy enemy's property. However, there are circumstances imperatively demanded by the necessities of war that you can actually do so. So, for instance, you would have you need a clear firing line. There's a building in front of it. The necessity of having a clear firing line would then probably allow you to then destroy that building to ensure that you can do your operations correctly. That would be an example of applying Article 23G, albeit in a land context. As a third one, military necessity also gives you the point of departure that choosing weapons and means and methods is not unlimited. Only lawful means and methods are allowed to be used. And for the ones that also are party to additional protocol 1, for instance, that will also then will tell you that in Article 36 there is a weapons review board, which means that every new weapon that you will acquire, you will have to go through the weapons review board. But basically says this is a new weapon. Would it fall within the principles of the laws of armed conflict to be for use? Can you lawfully use it then in that way? Now, on the one hand, we have military necessity, overarching concept, and the other overarching concept on the other hand, we have is humanity. Humanity forbids the infliction of suffering, injury, and destruction that is unnecessary. Here again, that word unnecessary, which is the important thing. There is this acceptation again that there is this idea that some suffering is necessary to do war. That's the part of military necessity, and there is this other bit that says that unnecessary suffering to accomplish a legitimate military purpose is not allowed. So it basically forms a counterpart or a counterpoint of military necessity. Force can be used, but you should minimize the suffering. There's a point of realism here also. Suffering is part of war, but it should not be unnecessary. Humanity gives you the fundamental safeguards for individuals and how to treat them, and it manifests itself in different facets of humanity. And one is, for instance, to respect, which means that the duty of abstention. For instance, the prohibition of torture or attack or maltreat civilians, or attack or maltreat persons that are hors de combat. So do not do something. And then there's the opposite, another facet of humanity, that's protect, that's do something, that's remove, for instance, as a law or as a rule, remove your hors de combat from the combat zones, collect wounded and shipwrecks. Now, it doesn't only translate in law, but it also perhaps also translates in different operational questions that you need to have. So if you need to protect your wounded, shipwrecked and sick, you might want to think about having some kind of medical facility also. You might want to think about that you need to have hospital ships or at least ships that have medical facilities. Clearly, of course, the question is where they would come from if you don't have them. Do you need to take them from maritime trade? Do you need to talk to the civilian organization to ensure that that there are agreements with certain states or certain shipping industries so that you can acquire hospital ships? We're going to talk about hospital ships later on in another lecture on protective vessels. But here's just an example of the Falklands War in 1982. This is the SS Uganda that was made into a hospital ship, and these are the Hydra, the Electra, and the Herald. Those were small oceanic vessels that were made into sort of ambulances ships to ensure that you could actually protect your own personnel and also the personnel of your opponent during an armed conflict. So it also has operational consequences. The principle of humanity, of course. Now, the other facet of humanity is equality, which means basically make no discrimination. For instance, on medical treatment. Medical treatment should be based on medical needs, and you cannot make any differences based on discrimination, race or religions. Those would be examples of rules that come out of the principle of humanity. Humane treatment, another facet, of course. No exposure to public curiosity, for instance, for persons that you have captured. And ultimately, also there's a number 5 prohibition on weapons that cause superfluous injury or unnecessary suffering are also forbidden. So those would be, let's say, 5 facets of different forms how the principle of humanity would manifest itself within the different rules. Here's just a small example of the maritime dimension of a rule in which those facets come back. You can see here members of the armed forces and other persons mentioned in the following article, blah, 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 who are at sea and who are wounded and sick. So the wounded, sick, and shipwrecked shall be respected and protected at all circumstances. So this is a rule in which those facets will come back. There's then the sub 2, they should be treated humanely, another facet. And then there's a point 3 here, which says if you have such persons parties to the conflict in whose power they may be, they should be treated without adverse distinction founded on sex, race, nationality, religion, and political opinions or any other form. So here you find an example of equality and the rule that no discrimination must be made. Another explicit rule here in which the principle of humanity has translated Article 18 of the Second Geneva Conventions. We should take all possible measures, so it's a positive obligation. We should take all possible measures to ensure that we can search and collect the wounded, ship and shipwrecked, and even the dead after maritime or naval engagement. So examples of rules that come from the principle of humanitarian humanity. Then we have the third principle, which is the principle of distinction. So the principle of distinction tells us that we need to make a distinction between basically 3 things: between persons, so a distinction between civilians, hors de combat, and combatants is the first. Then we need to make a distinction between objects, between civilian objects and military objectives. And then the third thing is that we need to make a distinction between weapons that can and cannot discriminate. So indiscriminate weapons are forbidden. Distinction, let me talk about that a little bit. Distinction is very important, and it's different than the reaction on distinction within the context of maritime law enforcement. Why is distinction important within the context of law of armed conflict? Because we have, within international armed conflict, we have status-based targeting, which means that once you have identified your enemy, once you have identified a person, that a person is a combatant or that a objective is a military objective, you can target it and you can destroy it. And there's no discussion or there's no thought in terms of, for instance, proportionality in the context of how do you call it? In the context of distinction. So if you look at it in the context of law enforcement activities, you also need to think about, because that is threat-based operation. So there is a certain threat, and you can distinct a person based on its threat. If it's a threat, you can use force against it. Laws of armed conflict will have status-based operations. So once you have actually assigned a person to be a combatant or a military objective, you can engage it. So there's a difference between distinction and maritime law enforcement distinction. Again here, if we go back to the factors and influences and historical practices, you will see that distinction is applied in a different way within the context of in the maritime dimension. As I mentioned already, platform-based targeting. So the crews, for instance, are tarred with the status of the ship itself. We won't go beyond the hull. We do have this discussion, and we'll touch upon that later, I guess, in the lecture on targeting on passengers, of course. And indeed, we have specific maritime rules that lead to issues that, for instance, if there is a merchant vessel that consistently refuses to stop, becomes liable to attack. And again, we have special rules on civilian enemy vessels in convoy and auxiliary vessels. Why is this made possible? Because of Article 49.3 that we have already discussed in the two lectures beforehand. Proportionality, as I said, and also the Newport Manual makes that distinction. It's perhaps not a principle, but it's a very cardinal basic rule because it applies in specific circumstances, in concrete circumstances. Here we have the rule from Article 51.5b from the additional protocol. For the ones that are not part of the additional protocol, this rule is considered to be international customary law, so we can take this rule as the point of departure. An attack which may be expected to cause incidental loss of civilian life or injury to civilians, damage to civilians and objects, or a combination thereof, which would be excessive in relation to the concrete and direct military advantage anticipated. So if we take this rule apart a little bit, then we come to these points. First of all, the rule says excessive. And again, here we find a bit of reality here in the laws of armed conflict. So not all deaths are unlawful. It accepts a certain loss of life. It accepts a certain loss of damage. The damage must be excessive. It's not extensive. So a lot of damage doesn't really matter. But it is about it's about excessive damage. And how should excessive damage then be considered? Well, it's a balancing act between the expected incidental loss and the direct military advantage. So if in that balancing act incidental loss is excessive, then it will be unproportionate to force. Now, of course, the expected incidental loss, I suppose, in relation to the direct military advantage is quite subjective. It's apples and pears. It goes back to the professional decision making of your commander. So that's a hard test to make a decision on. And then we have the word expected. And expected is also an important word here because the question whether something is proportional or not is based on information that is available beforehand. It is not based on the results afterwards. So all the information that we get on the beforehand is, and we make a decision upon that, that should be the question whether it's proportionate or unproportionate, not the results afterwards. I think it's important to also underline here is the difference between maritime law enforcement proportionality and laws of armed conflict proportionality, because to put it very simply, laws of armed conflict proportionality is about the relationship between the attacker and the one that is being attacked. Laws of armed conflict proportionality is not about the relationship between the attacker and the one that's being attacked, but about everything that is around it. Again, going back to the status-based operations, you don't need to think about proportionality in the context of the target because the target is already based on status, a thing that you can destroy. So you don't need to think about proportionality in the context of the target. You need to think about proportionality of everything that is around it. Then again, going back to the factors and influences of maritime warfare, you can see that in a naval context, proportionality usually not a super big issue unless you do operations very close to to ports or very close to coastal areas where there's perhaps a lot of fishing vessels and etc. Then it would be interesting to think about proportionality, which is basically also here what I say here on this slide. Not the targeted vessel, but basically everything around it. In the context of naval warfare, because we have platform-centric targeting, then we also do not need to discuss any persons that are on board the vessel. As Wolf has already explained, the crew of the vessels will basically be tarred by the status of the ship itself, which means that the persons on board will not be in the proportionality calculation. And one thing that is a contentious issue is indeed passengers and passenger vessels. Those are still a point of discussion. Okay, that brings me to the end of this short lecture. So we discussed 3 general remarks, and we've briefly touched upon the principles and basic rules.